So, hello, my name is Ethan Nadelmann. I'm the founder and director of the Drug Policy Alliance, a US organization. So just a heads up, the second and third speakers will speak in Spanish, and the first, fourth, and fifth in English. I've asked them each to speak for 10 minutes, and then I'll make some comments, begin a discussion on the panel, and then open this up more broadly, asking the English speakers to speak slowly, the Spanish speakers whatever they want. And so let us begin with Beatrice Labate, who has been one of the global leaders in the study of ayahuasca and a global networker, and also teaching and researching at CIDE, the Mexican Research University. Bea? I'll give you a 2-minute warning. Ready?
Hello?
Não? I wasn't to blame this time.
Bom, cansei, vou falar em português. Just kidding. Okay, I want to give my presentation and say how happy I'm to be here again and all of that. I just have some fragmented notes. It's not a really coherent presentation. I just want to put some thoughts out there. I think the format is meant to create a dialogue, so it's a little menu to invite some goodies that we can bite from and catch on for the later discussion. I just want to start by saying, noting the paradox of hallucinogens in the international drug public policy debate, because I would say it's a paradox because though ayahuasca or psychedelics are among the alleged listed substances, they're not really considered a legitimate topic in many ways within a more mainstream, broader movement of drug reform. It's not necessarily taken seriously. This is a paradox because in a way it's too small of a public problem to be a challenge to the conventions. This is what Amanda Fielding has called in the book that we just published called Prohibition, Religious Freedom and Human Rights Regulating Traditional Drug Use by Springer, which has also a chapter of Charlotte that she'll talk about in this roundtable. She named this the psychedelics and the trap of insufficient harm. So precisely because psychedelics do not figure in crime or health statistics, there is no compelling reason to re-examine their status. And just on a personal note, I share that in my current job about drug policy, I was hired to work in this university on the topic of drug policy and was so excited to finally have space to debate these topics. But within the range of my current job, ayahuasca is not considered legitimate, or peyote, it's not considered like a legitimate topic. And we're talking about drug policy. So I think that's a kind of founding paradox in the field of drug, relative to drug debates. But on the other side, if ayahuasca perhaps doesn't get all this critical attention, this visibility that it should get, I think it's a good example to think some of the main problems on the war on drugs. And here I'm talking of a more philosophical discussion, a discussion about the merits. So I would say that the war on drugs has, among many other features, I'm going to point out 3. It's an ethnocentric war. It's this idea that my substance is not a drug, but your substance is a drug. So alcohol or tobacco are not considered drugs, but other drugs are demonized. So it's an ethnocentric war because it involves ethnic persecution where certain minorities are marginalized. Then again, the uses of ayahuasca are a great example. of this marginalization alongside with many other historical examples, such as opioid and the Chinese, marijuana and the Mexicans, cocaine and Afro people, etc. So it's an ethnocentric war. On the other side, it's a cognocentric war because only the normal, only one type of state is considered normal. The rational, alert, waking mind state is considered legitimate, whereas all other kinds of states are considered inferior, as if they had less value. So human mind has many possibilities. Human life has full continuum of possibilities of understanding and of alertness. And we live in this paradigm that sleep or intermediary states, visionary states, altered states are considered less important. So it's cognocentric because it gives, in psychological terms, it recognizes legitimacy to only the alert, rational, waking state of being. And it's also an anthropocentric war. It's an anthropocentric war because we consider that we as human beings are the only ones with subjectivity and right for existence. Therefore, we are under the paradigm that plants don't have any subjectivity, they don't have agency, they don't have intentionality, they are inferior in terms of scale. So we as a human species are superior and we can decide to eliminate plant species out of the earth in this competition for survival among who has a right to be on planet Earth. We consider it as part of the mission, the war on drugs, to eliminate a whole species out of Earth. So this is this ambition to extinct other species, which is perhaps more clear in the case of coke. It's what one could call species centrism, considering that we are the main species, the main entitled to survival. So I think that although perhaps ayahuasca is not critical immediately in terms of statistics as a public problem, it's definitely, it raises many important sociological issues. Like through ayahuasca we can think all of these big questions that make the discussion of prohibition move around. And then I want to just, so these are two initial ideas. The third idea I want to put out there is that what has been said here a couple of times, the importance of thinking of the Brazilian model in terms of regulation. So what Brazil did was a true process of dialogue between different experts, both native users, by native I mean practitioners, not indigenous people in this case in Brazil, scientists and public government representatives. And through this collective process of dialogues, Brazil came up with a model that permitted the religious use of ayahuasca. So this model is the result of a dialogue between civil society and government, and it included multiple voices and perspectives. So I think that this model is also another good model to think possibilities of regulation in many places. Like we could use this ayahuasca model to a bunch of other substances. And then one final thought that I want to put out there, I think that the problem with ayahuasca is that it's something we discussed in the initial meeting, in the legal meeting we had today, that is the challenge of a unified model of regulation. So the current state of art, you have a great number of countries that have a sort of legal vacuum. Ayahuasca is not really an issue, we don't know what is their position, or it's explicitly prohibited. That's on the one side. On the other side, the uses that are regulated, they can be divided in two big models. Religious use, you have the countries like Brazil, Holland, Canada, USA, perhaps the UK, hopefully, we don't know. And other model that would be the therapeutic use. Peru, Colombia, I don't know if Chile, I'm looking forward to listening more about this. And other countries such as Spain, where it just passes personal drug use. So the problem of ayahuasca is that you have multiple contexts and different ways of using ayahuasca, and there's no real like universal model that unites all of this context. Plus, you have a lot of internal dissent or different views, disputes on whether which uses are considered legitimate. So there's several cultural and political views about what should be the regulated uses of ayahuasca. And in practical terms, we have seen a lot of difficulty in joint cooperation between different groups and branches, exactly because of these different views of what is considered legitimate in terms of the use of ayahuasca. So I think this is part of the discussion to think this was what I had thought for the internal meeting to establish whether we should advance a religious model plan or to advance a therapeutic model. And I think that's an ongoing conversation. I just want to conclude by saying that I think that in any case, independent of this possible consensus and coming together in convergences, the current state of the art is that prohibition weakens local and informal means of control. So I think that the culture creates a lot of means of self-regulation, and prohibition weakens this means of regulation of control. So we have to rethink in large scale the system of prohibition and claim some cultural right to use these substances in a more broader way, thinking about in terms of...
Okay, Bea, that's a wonderful conclusion.
Okay, thank
you. The next speaker, please. The next speaker, we are blessed, is so famous he goes by only one name, Rodrigo. Rodrigo Gonzálo from Santiago, Chile, who led the litigation on the case that is one of the most famous regarding ayahuasca in the case of Rumi, and won a remarkable acquittal. Rodrigo.
Thank you very much, Ethan. Does it work? Yes? Okay. Okay, so first of all, I'd like to thank ICIS, and especially Ben de Lernen and Jordi Riba and Jose Carlos Bosso, who I was lucky enough to work with in the Rumi case, and who by now I think I can call them friends. Basically, I want to talk about our experience in Chile of the case of my client Rumi, a vegan shaman who is sitting there. Rumi, you going to say hello or no? And I think it's an interesting case because this case, unlike many other cases, tackles the situation head on and from almost every angle from which the subject of ayahuasca can be argued. Perhaps the only exception was the religious sphere, which wasn't talked about at all because it wasn't part of the accusation. The case began in November 2009 when Rumi, who was a vegan shaman, did a session of ayahuasca with around 16 participants when the police interrupted the session, came into the house violently with guns, which they pointed at him, they threatened him, and after many hours of questioning of all the participants, the next day, Rumi was charged with drug trafficking. Specifically, the formalization said, and this was the same afterwards for the accusation when the case went to trial, for handing over dimethyltryptamine, which is a prohibited substance, which is in the regulation by the law on drugs, as well as by international conventions, and DMT, which is the psychoactive substance in ayahuasca. So we got together straight away as soon as the case got started, and one of the most important aspects for the defense was that the accusation was obviously poorly considered, as it was committing a basic error and showed a large level of ignorance, both regarding the public prosecutor and the police, because the species of plant, ayahuasca, doesn't contain DMT, in fact. So from that moment onwards, we realized that there was a hard nucleus from the point of view, from the criminal point of view, which we had to work on and would be key. And was key in an aspect which maybe isn't so interesting if you're not a lawyer, but it's the beginning of restrictive interpretation of the criminal law. And this is something which may seem like a technicality, but basically this is one of the guaranteeing principles for freedom for the citizens of the whole world. Crimes that are typified in the law cannot be interpreted, and that's why the doctrine has to be uniform in a broad vision. It has to be exactly what the criminal law says, and if it doesn't say it, it's not a crime. Not all behaviours that the established order can consider harmful or damaging, they are not all crimes. Only those which the law establishes. And in Chile, like probably in many other countries, the public ministry, which ensures that laws are complied with objectively, unfortunately always tries to go further, restricting the citizens' rights, taking away their freedoms, merely because they don't like them, because they're different or strange. So basically, the public ministry adopted an extensive interpretation of the crime, and we knew that that was going to be the hardcore of this particular case. And this was supported by the document, I think by now quite well known by all of you, which is the 2011 Charter. This was a letter, sent by the chairman of the council, the International Narcotics Control Board, sent to the Dutch Health Ministry, specifying that notwithstanding DMT is prohibited, that the species of plant and the potions made with these species that may contain DMT do not come under this prohibition. To be more certain in this case, in collaboration with Nadelmann, we requested him so as not to give a direct presentation by us. Nadelmann wrote to the new director, Mr. Lucas, if I remember right, from the International Narcotics Control Board, requesting an update of this declaration, which had been done several years ago. In 2010, 9 years after proceedings began, Mr. Lucas responded in exactly the same way. That is to say, the plant species, the concoctions made with those plant species, do not come under the prohibition. And technically, with this, we could have thought that the case was won, because this is a point of the law which is very important. But clearly what we wanted to do, basically because of the position of my client, Rumi, in the Chilean penal system, offers many different channels to avoid a trial. Conditional suspensions, reparatory agreements, all of these things which avoid a person necessarily going to trial. But here the dilemma was that Rumi wasn't being accused of something he just did once and didn't want to do again, but rather this was his way of life and something he identified himself with. And basically what he does is a therapeutic activity, which is perfectly legal, and so we had to fight it head on, and that's where two possibilities arose. Or lose completely, or win in every aspect. So we bet everything, and we went to trial with, apart from what we'd requested, well, it was very important in the system of oral trials, which is what we have in Chile, which is a tribunal composed of 3 judges who were listening to the discourse and listened directly to the witnesses. So it was very important that the tribunal knew Rumi's story in this case, and what we did was, in fact, Rumi testified for the first 2 whole days of the trial, showing the tribunal a series of photographs and videos taken in the jungle. And Rumi set up, through his own testifying, and through the questions that I was asking him, he was showing them what his training was as an Amazonian shaman and what the rituals consisted of, since obviously the public prosecutors and the members of the tribunal had no idea what the rituals entailed. And little by little the tribunal began to learn what it was all about. It's a completely new subject for them. But nevertheless, little by little, this thing that was so strange for them in the beginning began to take on some kind of meaning for the judges. And in this sense it should be noted that these were quite young judges, which I think is something we should be grateful for in Chile, that we have a reformed system regarding criminal proceedings, thanks to which the positions are now occupied, the key positions are now occupied by people who are much younger and much more open. Okay, sorry, I'll hurry up. So basically then what we did was bring out Rumi's patients who told the tribunal everything about their experiences, and they told some amazing stories about their recoveries and biographical data which had been completely forgotten, recoveries from things which had been very traumatic in their lives, which allowed the tribunal to see firsthand the effects of this therapy with ayahuasca. And of course, because we're in a westernized world, which is now a long way from these ancestral practices, we wanted to take scientific evidence, because despite of everything they were saying by the prosecutor, who knew very little about the subject and talked about risks which were not quoted in any specific study, and we offered them some fantastic presentations through Rodrigo, Jose Carlos Boso, and also the Dr. Jacques Mavid, who also gave a fantastic presentation. And other Chilean psychiatrists and anthropologists also gave their point of view, and we achieved a ruling which did not just dismiss the prosecution, it referred specifically to the difference established by the United Nations between pure DMT and ayahuasca, and also the ruling recognized expressly the beneficial effects of this alternative therapy, which in a country like Chile is very notable. So the situation now in brief, in 2012 the trial was concluded, and I don't think in a long time we will see, and in fact I hope never more, prosecution of ayahuasca in other countries, in our country, but notwithstanding the public health entity, based on other cases that are related with other things, expressly asked without any foundation the health ministry to prohibit ayahuasca directly and to list it as such in the list of banned plant species. And we're now talking with the health ministry and the Senda, an organisation independent of the Interior Ministry which deals with drugs, so that this prohibition requested by the public health entity not be accepted, and for us to continue in the positive situation that Chile is in at the moment.
The third speaker is Diego de las Casas, who is an attorney in Madrid, very involved with the ayahuasca cases, and also involved with an association called Plantaforma, not Plataforma, Plantaforma in defense of ayahuasca. Diego.
Gracias, Ethan. En primer lugar, quería agradecer a la organización AYCES por haberme invitado a participar en este congreso.
The organization AYCES for inviting me to this conference and onto this panel with such illustrious companions. So first, I'd like to talk about the evolution of the legal status of ayahuasca in the penal sphere that quite a few of us Spanish lawyers have come across in our dealings with ayahuasca. So at the beginning of the 2000s, ayahuasca was used in Spain, but actually there wasn't causing any problems. There was a proceedings open, however, with the Santa Daime Church in 2001, which meant that we, although there weren't any problems and we hadn't thought much about it, we did realize that ayahuasca was illegal. There had been a trial and it was ruled illegal. Subsequently, the years passed and there weren't any problems, and in 2010, the INCB, which is the International Narcotics Control Board, an organization that exists under the International Conventions on Drugs, in its report in 2010, it has a specific section on plants that contain psychoactive agents, and in this section it says, to be precise, hang on, I'm just going to find it.
La GIF entonces en el año 2010, disculpa que no la había cogido.
So the INCB in 2010, sorry I can't find it, puts in its 2010 report has a special section on the plants in which it says specifically, today there is no plant, including those that have psychoactive ingredient, which is subject to
activos que contienen pueden estar sometidos a fiscalización internacional. Por ejemplo, la cotina y la
active ingredients they contain might be subjected to international regulation. For example, cotina and DMT, which are psychotropic substances included in the first list of the agreement. As the plants and the preparations of plant origin which contain them, cat and ayahuasca respectively, are not subject to restrictions or regulations. And this report, in fact, what it does, what it means for the lawyers that are involved in ayahuasca, well, it shed light on this situation. It's something which no one tells you. Well, you look at the international conventions and you don't realise. You think if DMT is there, then the plant containing it is also going to be there. But once you see it, if you go to the conventions, the reality is that this declaration of the INCB is a reflection of what the conventions say. The conventions, when they want to prohibit a plant, they do it specifically. For example, cocaine is illegal, just like the whole coca bush is illegal. THC is illegal, just like the cannabis plant is illegal. So if you look at the 1971 convention, which only contains active ingredients and no plants, so it can be deduced that what is being prohibited is a plant and not the active ingredients. But this report wasn't written to shed light for us, to consumers and lawyers who are involved in ayahuasca. The report is more an outlining by the INCB of this reality. It's a report directed to the states, and it's saying that, these plants are not under international regulation, but at the same time directly commissions the states to carry out a study and to research in their own countries with the aim of seeing if these substances are being consumed on a large scale, and if it is happening, then the states can take internal decisions to prohibit it. Either way, for us, it did shed lots of light. And from this report, we can see that ayahuasca is definitely not illegal under Spanish criminal law. The Spanish Penal Code says that a substance can only be considered a drug when it is on the list connected with the conventions. If it's not on these lists, it can't be considered as a drug. Which means that since we saw this report in 2010, we are convinced that ayahuasca is not illegal in the penal sphere. But what has happened is that this report seems to have been cause for the Spanish government to carry out these controls, which are commissioned to every country. And the result was that since 1st of January 2011 until March 2013, in Spain there were 37 arrests over the possession of ayahuasca. As you can see, this is quite a cynical action. They're looking at part of the report, but the report is telling them that it's not a drug, but they're taking about 36 people to trial as if it were a drug. The reality is what happened, and that's when the work began, the practical part of the work began by the lawyers who are implicated in these subjects, helped largely by the plataforma of the use of ayahuasca, and also by ICIS. And this practical work consisted in explaining what we had read in the INCB report and exposing it wherever we could. We were telling people, we were writing articles wherever we could, and also in the cases that we had, and in cases where we contacted with those arrested, we told them and we told their lawyers. And the results of this practical work to start with surprised us how good they were. It seems like when truth is shared in that way and disseminated in various places, it's as if you're entering the collective subconscious and it begins to be assimilated. And suddenly, interpretations flourish in the same way that the INCB had said in quite suspicious places. Judges of second hearings began to defend this position. The police and customs sent us letters which defended this position. The experts, which are very important, the experts from the Toxicology Institute, which is an institute that analysed drugs for trials, also began to have and use part of this. But at the same time, we're seeing that some of this message has been badly interpreted, or the message hasn't hasn't arrived 100%. So let me explain. The first sentence does seem to have got through, which is when they say ayahuasca is legal. But however, through many of these parts of what are the institutions that have the executive power, the extra piece can then be seen, which says, however, DMT, which is contained in ayahuasca, is illegal. And that is nonsense. Makes no sense. Simple logic tells us that if the whole is legal, then its parts cannot be illegal, since these parts are contained in the whole. It could be illegal if you separate it, but the logical consequence of ayahuasca not being, along with other plants that contain DMT, not being regulated, it means the DMT which they contain isn't either, which means if we take advantage of having a forum which is quite broad, I invite you, I'm going to read out a sentence which, let's see if you can interiorize it and you can comment on it when you want, and thereby without too much effort and not even having to send out emails, let's see if we're lucky enough for it to be perceived and understood by our politicians, by our police force, by our judges and other members of the executive power. The sentence is the following: ayahuasca is not illegal because it contains DMT, but rather the DMT of ayahuasca, the DMT of the ayahuasca is legal because it is contained in this. Thank you very much for your attention.
Bronfmann, who is the principal figure in the UDV in the United States, as well as the principal litigator, principal legal strategist and plaintiff in the famous case in my country in which the US Supreme Court ruled unanimously in favor of the constitutional right to use ayahuasca as part of their church, as part of their ceremony. He also is unusual in having been involved in intensive negotiations with the US DEA, our federal drug police agency, in terms of dealing with this issue. So, Jeffrey?
So good afternoon, friends, and thank you to ECRs for this opportunity to share my thoughts and my feelings with you today. There's so many ways at looking at this issue, and I think where I come from is obviously I'm a religious practitioner. I look at this in terms of an issue of conscience, an issue of consciousness, an issue of spiritual autonomy, an issue of human rights, of basic rights. And I think when we talk about rights, it's important to consider that when we talk about rights, we have to understand, where do rights come from? When we claim that we should have a legal right to do this, where does this notion of this right, where does it originate from? What is law? And how does laws function to serve the reason why we're here on Earth? And I think that it's kind of going back to these original questions that I think create a context for how we could consider this issue of engaging with the natural world, engaging with plants in order to be able to enhance our understanding of the world that we live in, enhance our understanding of ourselves, enhance our understanding of nature in its evolutionary quality, in its spiritual quality, in its transcendent quality. And I think that often the languaging around substance use within the conventions that are the international agreements that relate to the use of substances that are controlled. There is basically what they describe them as being legitimate uses, licit uses, and illicit uses. And the only uses that up until recently have been considered licit uses, legitimate uses, are for medical purposes and research purposes. But the reality of the human experience is that there's been another use of particularly plants in relationship to our awakening to our purpose being here on this earth. And that is spiritual, that is transcendent, that is religious. And that there's been this symbiotic relationship between human beings and nature, where we draw our nourishment from nature. We breathe the air that the plants exhale. When we need medicine, it's to the plants that we go to find our medicine. It's from the plants that we nourish our bodies. It's from the plants that we build shelters. This symbiotic relationship between man and nature is fundamental to our existence. And part of that is that there are plants that are here on this earth that serve to awaken our consciousness to the reason why we have life, to the reason why we have existence. That they come from a divine intelligence, and that they help connect us to the divine intelligence. And so when we speak about a religious right, and as Ethan mentioned, in the United States, there's a constitutional right to the free exercise of religion. That's part of our Constitution. But this idea of where rights come from, the United States is a relatively recent democracy. And this notion of rights and natural law and where we derive rights is really a fundamental question. Do governments give us the right to be happy? Do governments give us the right to health? What right do governments have? And there's this idea of a social contract, of an agreement on the part of citizens to yield certain authority, certain freedom to the state in order for the state to govern in the public interest, for the public good. But there's a notion of inalienable rights. There's a notion of fundamental rights that come with the fact that we exist, that predate governments, that go back long time ago when the first human beings started to take life on this earth. And those are the rights that I think that we're particularly moved by among this group of people. Because the use of what we within our church speak of as ayahuasca, what many people understand as ayahuasca, interestingly, it's often misunderstood. Some people talk about ayahuasca as being a plant. The traditional brew, the traditional decoction that today we know of as ayahuasca daime, is the union of two plants. One masculine nature, one feminine nature, that united together reveal the nature of the divine, the nature of the invisible world, the nature of the spirit world to us. And so this notion of the sacred, I think, is really important. You know, in all the conversations about science, I think one of the dangers is as we go into this realm of studying this phenomena and exercising this phenomena is the risk of materializing something that's inherently not material, of looking at something that's inherently of a different quality, of a different nature, and treating it as if it's a substance, and speaking of it as if it's just. But there's something very unusual about, you know, these plants in terms of what they can reveal about the nature of life, about the nature of truth. I've been doing this for close to 25 years now. And before my experience with the UDV, where I was introduced to the practice, I had experiences working with indigenous tribes in Mexico and in other parts of South America using other plants. And it's been a quest of mine to gain a greater understanding of myself, to gain a greater understanding of the world that I live in, and my relationship to the world, my relationship to other people, my relationship to the superior intelligence, to the life force, to the spiritual world. And so I think that there's something, I think it's not an accident in terms of the way that this movement is progressing, that in a sense it's the religious traditions that are kind of leading it, the recognition of there being a sacred dimension to life that perhaps can open up other things in terms of healing. In Brazil, which has done a remarkable work as be acknowledged in terms of the leadership of the multidisciplinary attention, that when the use of these substances started to reach the attention of the authorities, they didn't prohibit it. They decided, let's study it. Let's see why these people are motivated to use it. What's happening in their lives as a result of their use? And the decision was it made them happier people, made them more productive people, healthy families, and they decided it was a social benefit. Why prohibit something that was actually doing benefit for people? And I think that context is really important. Context for the use, context for people to be supported in their inquiry, and that there's a certain ethic. I was studying this whole notion of law, and when did this idea of rights start to come into the conversation of law? And I found out that it happened in the Roman Empire, about 100 years before Jesus was born. Even before that time, there was already talk about there being the need for people to have a relationship with the divine, a relationship with some power that was superior. And there was and the idea of there was a distinction that was made. This was the work of Cicero, where he talked about that law does not and cannot begin with men, Men to him are the instruments of a higher wisdom which governs the entire earth and has the power, through shared morality, to command good and forbid evil. Cicero also made a distinction between legalism, which is written law, and the law, which is a sense of right and wrong as dictated by eternal wisdom. And I think that acknowledging that this dimension, that there's a dimension of morality, there's a dimension of right and wrong, there's a sense of justice that's transcendent, is really what, properly used, I think people can experience, through the use of this sacred tea, to be able to gain consciousness, to be able to see the nature of ourselves. And so we went through a process in the United States of, on the basis of this religious right, seeking recognition by the government of the United States. And as Ethan mentioned, and I could talk about more if there's questions, we went through a process of negotiate an agreement where today the União do Vegetal in the United States holds licenses for the legal importation, the legal distribution, and the legal storage of the sacred tea under the authority of the government with, the flag of the United States and the stamp of the Drug Enforcement Administration, all signed and approved, and we come in through the customs service and they stamp it and we enter the country and our ceremonies are able to go on. So it's in a sense of victory of being able to, as an alternative to between prohibition or no control, to have a system of regulation whereby it was negotiated, we're fine with all the terms that we agreed to, and it gave the government a sense of their place being honored in relationship to their responsibility for protecting public health and the well-being of its citizens. So it was, I think, an important model as this movement continues to grow and flourish around the world. So thank you.
Okay, Jeffrey, thank you very much. And so the next speaker is Charlotte Walsh, who is a legal academic at the University of Leicester in England, and who has been doing all sorts of work with plant psychedelics. Charlotte?
Okay, hi there, everybody. So I wanted to kind of broaden it out a little bit and look at cognitive liberty and psychedelics more generally, so including but not restricted to ayahuasca. And I recognize right from the off that from some people's cosmologies, even describing ayahuasca as a psychedelic might be problematic, but that's my term. So we've been seeing that there's a tendency for psychedelic users to claim the labels of either religious or therapeutic use when trying to exempt themselves from prohibitive frameworks, both because this is a genuine description of the activities that they're engaged in, and also because there's obviously protective power attached to these categorizations. And I fully support these initiatives. But I also think that we should take these arguments further, and that we should argue that such exemptions should also apply to those who have perhaps more loosely spiritual experiences on psychedelics, unbounded by any established framework. And even beyond that, because thinking about what would it even mean to describe an experience as categorically non-spiritual. So Jeffrey's just been talking about the sacred. To my mind, there is no clear division between the sacred and the profane. And certainly once you add psychedelics into the mix, I think it kind of fudges the issue even further and sort of exposes the inadequacy of any such binary distinctions. And visionary experiences can creep in unbidden. And I think that, a sense of awe in the face of the newly revealed beauty, magnitude, and fundamental interconnectedness of the universe is maybe not so very different from a professed belief in God. And even if there were such a thing as a categorically non-spiritual experience on psychedelics, does it follow that that experience shouldn't deserve protection? It might still be of equal significance to the individual involved. And then again, it might not. And should that even matter? So really the idea that whether or not it's believed that individuals should have to justify their substance use on any grounds is bound up with one's view of the proper relationship between the individual and the state. And it's my belief that society should work towards maximizing everyone's autonomy rather than reifying therapeutic, religious or spiritual practices. And accordingly, it shouldn't be necessary to have to try and contort our experiences in these more kind of amorphous realms into a shape that approximates those of established religions, or to try and determine this sort of impossible question of what constitutes a spiritual experience. In order to be able to be afforded human rights protections. So the heart of the issue really for me is whether or not it's justifiable that designated experiences involving psychedelics might be protected, whilst other experiences potentially of equal importance to the individuals involved leave them open to criminal prosecution. Happily, in Europe, Article 9 of the European Convention on Human Rights protects not only freedom of religion, but also freedom of thought, cognitive liberty, the right to control one's own consciousness. And if you think about the inextricable relationship between thought and neurochemistry, obviously controlling the chemicals that we can ingest can be seen as an interference with cognitive liberty, as a form of censorship, curtailing the mental landscapes available to us. And I really liked Bia's description of our laws as kind of cognocentric. I've not heard that before, I liked it. And I think the fact that most governments have effectively criminalized unorthodox mind states is deeply problematic in terms of the appropriate relationship between the individual and the state. And cognitive liberty is a concept with deep roots. It can be seen, I think, as a natural extension of the classic liberalism espoused by legal theorist John Stuart Mill. And Mill, as I'm sure you know, was concerned with the nature and limits of the power that can legitimately be exercised by society over individuals. And he thought that we should take the devastating power to impose punishment of the state seriously. We should take that power seriously. And he importantly laid down the principle of prevention of harm to others as the necessary precursor to justifiable criminalization from a liberal perspective. And this approach rules out laws that are paternalistic, that are rooted in moralism, for example, though unfortunately these doctrines still seem to infect drug policy. So liberty, cognitive liberty, comprises freedom to choose, including the freedom to take what others might consider to be bad choices. And really, how could it be otherwise? Who, other than ourselves, should decide what is of value to us? And it's through our choices, including those regarding which substances we choose to ingest or not, that we engage in self-creation. And when the law limits those choices, it limits who we can become. And liberalism rejects such paternalism. How can being subjected to state punishment possibly be for one's own good, when the primary and often solitary harm being suffered is that inflicted from on high rather than from having been high? And with its implicit infantilization, paternalism is deeply problematic. It should remain up to us as individuals, not the state spuriously on our behalf, to prioritize whether or not we accord greater value to the possibility of, say, a mystical experience versus an outside risk of either physical or psychological harm. So, in line with Mill, I would advocate a negative liberty, the freedom to be left alone to do as one pleases. But thinking about the fact that as the psychedelics often render kind of vividly apparent, human beings are all inextricably interconnected with each other, along with the entirety of the biosphere and indeed the universe. We're all woven of the same molecular fabric. So thinking about, does this fact not create societal obligations, meaning that judgments relating to whether or not somebody can ingest a substance can't just be taken at this kind of atomized, individualized level. And of course that's true, but in line with the harm principle, we should only make incursions into those free choices where taking a substance would create real, measurable harms in society. All of our actions affect others. The question is whether or not they set back others' interests sufficiently to warrant criminalization. It's out of recognition of the fact that some actions can impact on others to the extent that does justifiably warrant state interference, that there are qualifiers to Article 9 of the European Convention. So Article 9.2 says that we can kind of eat into these rights in the interests of public safety, for the protection of public order, health or morals, or the protection of the rights and freedoms of others. And these qualifiers not exclusively, but on the whole, seem to arise from concerns about tangible harm to others. So they're sort of largely unproblematic in theory. But what's more contentious is the ease with which these qualifiers are engaged in practice when we're looking at cases involving substance use in the courts. And in the courtroom, these supposed harms are rarely empirically demonstrated. So I'm not denying that psychedelics can lead to harm. Different substances are obviously associated with differing risks, but rather that in court these harms need to be proven rather than assumed. The public has the right to be protected, but if we just kind of spin these worst case scenario ideas in court, then we're effectively kind of hollowing out the protections that Article 9 should offer. And what ends up happening is that the courts avoid protecting certain people's freedoms when to do so is seen to be unpopular, either with the public or with politicians. So you get what looks like legal objectivity is really value judgments. Okay, so where human rights and freedoms are being restricted, the burden of proof as regards harm to others should be on the state, so that these protections actually mean something. Much finer distinctions need to be drawn between the different types of controlled drugs and the ways in which they are taken when assessing whether or not they're a threat to public safety. We need a much more parsimonious and much more kind of evidence-based approach in the courts. And also, if we're going to take a proper balancing exercise under Article 9, we need to weigh potential harms against the benefits of psychedelics. And the fact that these substances might advantage their users remains largely absent, both from policy documentation and from the language of the courts. So, for instance, the idea that people should be allowed to take psychedelics because they enjoy them is rarely invoked, as though pleasure were a dirty word and we need some kind of like higher motivation to get high. And obviously no one here needs me to tell them that along with pleasure, psychedelics might lead to great benefits, both for individuals and then obviously consequently for society as a whole. They're inextricably implicated in the development of the environmental movement, the development of computing technologies used widely in psychotherapy, and on and on. You're all aware of this. So really saying that, in short, given that the great benefits that so many claim from psychedelics up to and including achieving enlightenment, it shouldn't be necessary to prove that these substances are risk-free in order to avoid the clutches of the qualifiers, because like most things, obviously they're not, but rather for the state to prove that the harms to society actually do outweigh the benefits. And in one sense, what I've said can be seen as a radical argument. To argue for a right to psychedelics as a component of freedom of thought is to do a lot more than to ask for limited therapeutic or religious exemptions. Indeed, it threatens the very structure and existence of global prohibition. That's kind of the point. And on the other hand, what could be less radical than arguing that we should be allowed to control our own consciousnesses?
Okay. Thank you. Charlotte, thank you very much. So let me offer a few comments of my own and then open this up to a discussion on the panel and then all of you. I spend relatively little time in my life with ayahuasca or other psychedelics, for whatever term one likes. What I do is I run the leading organization in the United States trying to end the war on drugs, both in my own country and elsewhere. So when you read in the newspapers about the efforts to legalize marijuana for medical purposes or more broadly, or the efforts to counter our infatuation with mass incarceration, or the efforts to reduce the spread of HIV among injecting drug users, or to reduce overdose fatalities, or to transform U.S. foreign policy with drugs, that's the work I do. That's been my commitment in my life, and it will continue to be. And so for me, the psychedelics have played a relatively small role because in a way, the persecution and prosecution of people for the psychedelics pales compared to what's going on with marijuana and heroin and cocaine and all these other things. That said, why am I here? Well, first, I have a personal interest in ayahuasca and in the plant psychedelics, and they have played a beneficial role in my own life. The second reason is that any time I see people being targeted and punished by the state because of the substance they are putting in their body, I regard that as a proper area to focus the energies of drug policy reform. And this is a group here, and many of you have been through that experience. And so rolling back the role of the state, and especially its criminalizing roles, is a fundamental mission for me and my organization and the growing drug policy reform movement. Now, it's also the case that in building a political movement to end the war on drugs, one needs to build both alliances and consciousness among the varied individuals and leaders and groups and organizations and officials and what have you who focus on just one aspect of this struggle, right? There are people who focus just on the issue to make marijuana legal for medicine, and others to legalize hemp for agricultural and hemp purposes, and others to end marijuana prohibition entirely, and others to reduce the racial injustice of the drug war in my country and many others, and others to reduce incarceration, and others to deal with the environmental consequences of the drug war, and others to reduce the harms of the drug war on people who inject drugs, and others who focus on trying to educate in new ways, and others who fight for cognitive liberty. All of these different groups, and many of the people in these groups focus just on the one piece that they're working on. And sometimes their success in moving forward to legalize medical marijuana depends upon disassociating themselves from everything else. The effort to legalize one psychedelic, or, let's say, or the one church, moves forward in part by separating itself from the broader drug policy reform movement. To move forward on the racial justice aspect by dissociating itself. And that is sometimes tactically necessary. But in building a movement, what's most important is that people working in any one area, even if their focus, their public focus, the passion is on that specific area, that they at least share the broader consciousness about the need to end the war on drugs, and that they recognize that victory in their one area will not lead to the world that we all need to fight for. Now, for this group here, for all of you who are brought together because of a special relationship or interest with ayahuasca, well, we're here because we don't like, and one reason we're here is because we don't like what the state is doing, the criminalization, the stigmatization, the demonization of that. Right? We're here in part because we recognize that there are principles of cognitive liberty that are involved. But I'm also here to appeal to you not to segregate yourselves, at least in your own consciousness, from this broader effort to end the war on drugs. It's to understand that cognitive liberty should not apply just to the most elevated of the substances, to ayahuasca or others that we put in that category, but that ultimately that principle needs to apply to all substances, even the ones that we look down on as being associated with degradation and people we may not associate with. It's understanding that, yes, you and I may agree that ayahuasca is elevated and is a special thing, not just the drug, the plant, but the context in which it's used, but I can point to you a book called Opium and the Romantic Imagination, about the wonderful writers who wrote wonderful, famous books under the influence of opium. Or a book called The Thirsty Muse, about the wonderful books written under the influence of alcohol. Or a book called Cigarettes Are Sublime. I would wager that half the great books written between 1930 and 2000 were written under the influence of that most powerful of substances, nicotine. We know that cannabis has not religious roles and therapeutic roles and all sorts of other roles, right? We know that for some people, their mental illness untreated drives their artistic creativity, and that for other people, antidepressants is the thing that allows them to function and be productive. So we have to beware of having some sense of ayahuasca supremacy, of ayahuasca exceptionalism, even if we live and breathe ayahuasca exceptionalism, not to impose those values, not to demonize the others because of our own special experience. And recognizing, because all of us here live with the experience of having to worry about the state and its powers to prosecute and persecute, we all therefore should have that extra element of empathy for people using other synthetic and plant-based chemicals and substances to alter their consciousness for better or for worse, and being persecuted 5 and 10 and 100 times more harshly because of that. Now, that said, because I'm the moderator and should not take up more time, I will leave off the rest of my comments. And I will instead frame the first question for this panel here somewhat along the lines of where I next wanted to head. This session here is called Law, Policy, and Human Rights. We've all spoken on one way or another about human rights, to use ayahuasca for religious purposes, therapeutic, or broader purposes, as Charlotte said. But let me ask you this question. We all know that the role the state is playing in most cases, apart from a few select countries, is not right. But what is the appropriate role of the state? Is it just to get out of the way and play no role at all? Or do we actually need them to play some role, given the potential for what happens when the state steps entirely back? Who would like to start? Bea. Bea.
I just want to make a comment about your previous comment that what you called ayahuasca exceptionalism. I think that's right to the point in this community. On my personal life story, I drank ayahuasca, and like a lot of people, you know, got that little messianic thing that this is wonderful and it's a revolution. And I started off thinking that it was really special and different from everything else. And for me, initially, in my first years, it was very shocking to try to compare ayahuasca to things such as cocaine and other things. And I really thought, people who say that, they don't get the point. And it was a process of education, of thinking in a higher, like more sophisticated level, that all these substances share the same common philosophical problems, and that prohibition is affecting everybody. So I really encourage this line of thought, because I think it's like an education process to people to make that bridge. It's beyond just having the religious inspiration, and it's about some intellectual reflection. It's not about your personal choices, like do I like cocaine or do I like heroin or do I like marijuana, but it's about what this means. It's just like, to make an analogy, if you're going to support gay marriage, it's not about whether you want to engage in homosexual relationships, or if you want to support the legalization of abortion, it's not about whether you would personally choose to do an abortion or advise your daughter to do an abortion. It's about a wider reflection on the implications of those things. So I think that's the natural path for everybody to, once they start thinking about it, that it's a boomerang logic. If you don't criticize the structure of the logic, you're throwing that boomerang back to you, because that's just going to be coming back to you. That's what happened against me. I was associated in Brazil with defending marijuana use, like maconheira, which is kind of funny because I don't smoke pot, but I was seen as this person that stimulates pot use because I defended freedom for anti-prohibitionism, And then I was charged legally because I was advocating like proselytism of drugs. And a lecture of mine was taped, and when the public ministry analyzed, I was like denounced because these people were thinking I was doing proselytism of marijuana. And when they analyzed the case, what they said was that I was doing proselytism of ayahuasca, and I was charged for doing proselytism of ayahuasca. So the people that wanted to criticize me were trying to aim my advocacy pro-marijuana, but in fact, the state interpreted as advocacy pro-ayahuasca.
So let me, now you turn that off, I think. Since Bea took the liberty of ignoring my question, but making a very valuable comment, what I will do is, instead of imposing the question at the start, let me ask, is there anybody else who would like to offer a comment in any way about the other comments? And then I'll return to my question. Okay, anybody? Not to my question, but generally speaking about the other discussion?
Yes, very briefly.
Yes.
So about your commentary, not about the question.
Okay.
Okay, about your commentary, I want to say that it makes absolute sense for me, because my motivation here is not because I am a believer for the ayahuasca or that I have a special relationship with it. My only special relationship is with my client, because my motivation is freedom, is to protect the citizens, the rights of the citizens to do what they are entitled to do and to experience. So I couldn't agree more with you. And of course, the problem of drug is a lot larger than ayahuasca problem, who is not, in fact, I know this is very important to you, but in percentages is nothing comparing with the other main problems of drugs. And now I will refer to your question, because maybe I haven't given enough thought to that. I am a strong believer that the war on drugs must end, because it causes so many damages in human loss, human lives, and incarceration, of course, but a lot of violence also. My main concern in the problem of the war of drugs is the criminal organization and the control that the cartels takes in vast zones of a number of countries, especially Mexico, maybe. But answering your question, I'm not very sure, but I think that the state, first of all, it must resign his oppressive attitude, of course. But I think that the state, and we will not be able to see it for many years, I'm convinced of that, but the state has a role to play, necessarily. But it will take a very, very long way to do that, because all the hypocrisy about the subject. But, and I cannot imagine now, I don't figure really how the state would play that role, but I imagine that, first of all, it could make sure to provide good quality drugs for not having diseases derivated for bad quality. And of course, there are a lot of drugs. I'm not saying that ayahuasca is one of them, but there are a lot of drugs that causes serious health problems. So the state has to take care of all that. So I think that, yes, I have not this all liberal speech of the 18th century of Adam Smith. No, laissez faire, laissez passer. No, it's not the answer.
Let me, I think probably all of us would agree that when it comes to that no human being should be criminalized simply for what they put in their body, absent harm to others, and that would apply to all substances. The general consensus on that? So then the question becomes, but when it comes to the production and the distribution, and who plays the role of the gatekeeper And with what role does the state play in sanctioning a gatekeeper? And so, Jeffrey, I want to put you on the spot because in some respects, you have involved both in terms of your negotiation with DEA and fighting this case. When you think about the role, is there a proper role of the state? What should it be? What do you think?
Well, I can speak about our experience. Our position legally was that the state had no place in regulating our use. And we were basically put in a position where we had to negotiate with the drug enforcement authorities in order to be able to have our use registered and have some degree to which it was being licensed. So we had a say in terms of what aspects of our practice lend themselves to being licensed, that actually served our practice, and what aspects we felt were an intrusion on our fundamental freedoms. So for example, an example of regulation that served us is by having these licenses that allowed us to import the tea from Brazil into the United States, we could present it to the US Customs Service, we could be ushered through the US Customs Service, and it was a way within which our freedoms were being facilitated by being licensed. An example of the ways in which we consider it to be interference is in the pharmaceutical area, for example. The state has the authority to license who gets to distribute certain substances as pharmaceutical drugs. Our position was that the decision of who distributes the sacrament should be up to the religious leadership, not up to the state, who should license. And so I think that that's two good examples of ways within which licensing can serve and where regulations can serve and elements of state cooperation, not in terms of control, but to facilitate, health. And I think that as we come to define models that constitute, because typically if there's going to be some abuse of power in relationship to the use of ayahuasca, where there's harm, it's because there's some other form of human conduct that's improper that comes into play, whether it's sexual exploitation, financial exploitation, abuse of power, and those are all things that are already regulated by laws. And so I think that I think that the role of the state would be very limited, and I think that the state has other things that it needs to be best, dealing with. And I think in terms of identifying authorities that could advise the state with relationship to how to conduct and develop a policy. I think that Brazil was very wise in terms of seeking anthropologists and social scientists and religious scholars, as well as medical scientists and psychiatrists in developing their drug policy. And I think that often the people who administer public policy are really unqualified. I think this is something that's come out here is that the current drug laws are not based on science. They're not based often on anything but prejudice. And so I think a way for the government to become meaningfully involved would be to bring into the conversation people who are recognized authorities and really know what they're talking about.
Thank you. Charlotte, you referenced John Stuart Mill's classic book on liberty and his distinction between self-regarding and other-regarding behavior, and his argument that the state has no role in regulating self-regarding behavior, but only other-regarding. But on the issue of what role the state might play on the production and distribution, there is less said, except perhaps the suggestion of a regulatory role. So what do you think with these planned psychedelics?
I think I'm a big fan of bottom-up kind of grassroots power and minimal state interference in these kind of areas. So I think that the ayahuasca community should be predominantly self-regulating, and I think that through kind of self-generated initiatives you could achieve the level of standards and quality that you want, but rather than it being backed up by sanction, it would be kind of driven by reputation, so sort of organizations like this. But I think that would be my kind of like utopian way of doing things. But I think realistically, if we're going to sort of wrest power away from prohibition, it seems I think that would be quite difficult to achieve. And it might be that we go sort of out of the frying pan into the fire, and from prohibition to to regulation, and it might bring in all kinds of restrictions that people really wouldn't welcome. So we don't live in the kind of society where people are just sort of left to their own devices to self-regulate. I wish we did in many ways. Obviously, some things need to be centralized, but certainly in terms of where the expertise is in these sort of specific groups, I'd like to see it remaining there. But I don't really fancy the chances.
So, Diego, you made a provocative argument. You said that, and it was almost the opposite of one that one typically hears. You said, if the plant is legal, it seems illogical to make a derivative, a chemical within the plant, illegal, right? Now, oftentimes we have the opposite. The plant marijuana is illegal, but the drug THC is legal, right? The poppy plant may be sort of legal in some places, but then different products will be legal or illegal. There seems almost no coherent principle. Explain a little more why you think I mean, are you essentially making an argument that the state should not regulate anything and just leave both the plant and the chemical out of its control, or?
Bueno, Ethan.
Okay, Ethan, so today the active ingredient is illegal. What isn't criminalized is the plant, the complete plant. So it's simply a logical interpretation. You have a whole which is legal, you can't make the part illegal. So what I maintain is that DMT is being legalized because it is part of a whole which is legal. And that sometimes is difficult to understand with ayahuasca as a final product, which is the ayahuasca drink, because when you explain this to the judges, one of the things we have to explain is that this is not a doctrine for ayahuasca, it's a doctrine for the plants. What we're saying is that a plant is legal, whatever it's got inside of it. But if you go to a park and you see an acacia, you're convinced that the acacia is legal, but in an acacia there's DMT, but the DMT is illegal, but it isn't until you take it out. So as a consequence, it's something which is accepted by all the judges and the states, that ayahuasca is not an extraction but more of a potion. So ayahuasca is considered to be the plant, and so as ayahuasca is legal, like a tree is legal even though it's got DMT, while the DMT is inside of the ayahuasca, it is also legal. So regarding what the state must do, with regard to ayahuasca, I don't think we need to be changing the conventions, because actually they suit us. They're saying ayahuasca is not legal. What there has to be is an effort to spread information, so that this interpretation, which I believe to be the right one, is heard by judges, the police, by the customs, etc. And what is true, now connecting with what Charlotte has said, that after its criminal legalization, which means taking it off the list, we have to be very careful about the way it's regulated, because sometimes poor regulation could be worse than making it a crime. Okay, so I don't go to jail, but if they give me a fine of €1,000, that's a big problem for me.
Which is, if you imagine the spectrum of possibilities of the role of government, at one end you have the total prohibition of the substance and everything involving it. At the other end, you have an absence of government control, a free market. In the middle, you have various degrees of ending the criminalization of use and possession, perhaps regulation of various forms, from more prohibitionist regulation to more easy, lenient regulation. And what we know is that every place on this spectrum has pluses and minuses. In a prohibitionist environment, people get hurt and punished by the state, but the communities engaged remain fairly intimate and closed and special, right? With regulation, you reduce the harms of the state, but the state has an unlimited capacity to regulate stupidly and to show its own preferences and be political. So one has to deal with all of that. And as we're learning now in the United States, with the legalization of marijuana, we are going from dealing with the problems of the prison industrial complex to now the problems of the pharmaceutical and corporate and other powers. And then you have on the final end the more commercialized, closer to the free market, possibly regulated. So I was curious to hear at this conference about Peru, which seems to have the most easy policy with ayahuasca, not just for religion, but for others. And sometimes I wonder, well, I mean, ayahuasca. So what if it were available freely? I mean, let's market a substance that causes horrible visions, nightmares, drags up your primitive childhood, and causes you to vomit 9 times out of 10. Probably not a substantial market for that. On the other hand, the capacity of corporate forces to derive the DMT, to take the chemicals, to promote it, to do, maybe creates an opening. So the question I want to throw out here is, when you think hard, whether it's specifically the Peru scenario right now, or allowing this to be much more free, would that be a better world than we have right now? Or worse? Hard to say. What do you think?
I want to make a remark that Peru is not a free world, because what guides the use in Peru is tradition. So I am an anthropologist. I think the role of an anthropologist in the drug reform debate is to point out to the importance of social and informal means of control. So there's nothing like a total wild use. This use is already regulated in reality. There's traditions, there's parameters, there's rules, there's enforcements. Even if you think the role of gossip, of one group criticizing the other, that's a kind of mean of control. So I think that what we have to do is, I think it's a little bit like a fiction to think that this would be a total wild, like Old West scenario where there would be no controls, but because these controls, they already exist. They exist in reality. People internalize controls. The whole point, like the whole anthropological discourse on the legitimacy of the use of drugs is to go look in reality and check what it's already going on. And what is already going on, it's a deep sense of respect, a deep sense of order. And if you compare to any situation, I mean, think about something like Carnival in Brazil. The millions and millions of people that go and drink a lot, and everything that happens, like, or any parties during the weekends, compared to ayahuasca ceremonies, I think it's remarkably organized and self-regulated and integrated and functional. So I think that I am in favor of a more, tolerant spectrum of use, and I think Brazil is a great example of that, alongside with Peru. There's a multiplicity of models. It's not a monopoly of one right way, and many little initiatives and particular groups have developed all sorts of combinations and of rituals, of hierarchies, of collaborations, of rules, of inspirations to guide that use. So I think that we have to cherish the importance of self-regulation, and people, it's much more efficient if you learn to do things. It's like we have this model of prohibition, and on the other side you have this model of, for example, let's say enology, the enology of wine. So people learn how to, plant the vine, the grapes, and collect the best wine. There's this whole positive culture on how to use the substances. So I think it's about shifting a discourse of prohibition to a more, to an education about the benefits of the substances, the virtues, the multiple ways. People should be taught on, how they should store, how they should transport, how they should consume. And there's a huge culture about this.
The role
Oops.
That what you say about culture makes enormous sense, and education and community. But it still begs the question, where is the state in all this? Where is the state, the government? Is it just standing back? Is it?
I think, of course, like, the state has to be acknowledged. Nobody's gonna like be naive and say no state, because the state is everywhere. Nobody's gonna be naive and say no capitalism, because capitalism is everywhere. We have to deal with the reality as it is. So I don't think we're gonna invent an anarchy of ayahuasca in the middle of, you know, a system of democracies and international representations. The state has a legitimacy. The state is important. The state is a legitimate player, and the state has to be heard. We can't be authoritarian and utopian or messianic and say, we're going to put our rules there. The problem is that there is a disbalance. Currently is like the state rules and a bunch of like very conservative medical doctors with very weird ideas bounding with the state saying this is what we have to do. So I think it's about distributing better the powers. The users should be heard. That's a very basic idea.
State sanctions and gives doctors in most countries the authority to be the gatekeeper between certain pharmaceutical substances and others, right? In the case that Jeff was involved in, the state plays some role of effectively licensing religious leaders to be a gatekeeper. That power of the state to prohibit or license or assume the role of the gatekeeper between the substances and the consumer, the practitioners, that question of what that role should be. Yes, of course, we all agree about culture and that, but that very difficult question, because we're talking here about law and policy. Does anybody else want to try to jump in on this? I've thrown a very difficult question, I know. No. In that case, we will turn to the audience, and Casey first. And are there any microphones in the audience? And I have no way, here. The speakers, if they could just come.
It's going to work?
Yeah.
Yeah, it's going to work.
And I'll grab it from anybody who speaks too long.
Yes, I bet he will. One of the founding fathers of the United States of America said something to the effect of, the government is instituted to protect property of every sort. The first question I want to know is whether I'm the state's property or not. And if I'm not the state's property, do I have full property rights over my organism? And when we look at drugs in particular, what the state is regulating is actions by humans. It's a verb: production, supply, possession, and use. These are actions that humans take. That's my property, taking another piece of property and putting it into my body. I can do that lawfully with tobacco and with alcohol in this country, in this auditorium right now, but were I to do it with other types of property, I'd be breaking the law. So this really boils down to what Saz was talking about, a property issue. When black people were traded and sold as property, we didn't unlock slavery until we reversed it and said, wait a second, the black man, the black woman, the Afro people, as Bia said, the Afro people own themselves. Do we own ourselves? And what property rights do we retain? And what property rights do we want to give to the state?
So, what I'll do is I'll take, please, anybody else, what time are we supposed to end? 8:30? So what I will do is maybe if a few other people have questions, come up now. We'll take a bunch of questions, remember them, and then we will try to take them and see how they group together. And say your name.
I'm Pete from Florida, and my concern is if crack cocaine is sold at the neighborhood gas station, the same thing would happen to the African American community that happened to the native Indians with alcohol.
Yeah, my name is Jonas, and I would like to ask the opinion of the people here at the table about this idea that what the state could regulate is not my personal choice of ingest a substance, but what has to be with the dealing, with the business, with the selling, because this is happening with any other kind of product, like petrol, food, and buildings. So that we could say it's legitimate that the state rules about that, and could be, for example, an idea to have, as in the United States, there is the Food and Drug Administration, to have something similar for psychoactive agency, to think who has the license, who might receive the license to sell or to distribute. But for the personal use, I think we all agree that the state could just step back and say, it's not our business. Like if somebody has a problem, a physical problem, then it's a health issue, it's not a criminal issue. So what do you think about the idea of an agency that is ruling about the licensing of distribution and selling? It makes sense. For me, I don't know.
Okay. Thank you.
Hello, I'm Sita, also from the United States, like a few of you up there. And my question is, what is your, and inspired by Bia, thank you so much about your comment about the cultural perspective. What is your level of confidence in our ability to be the state and to allow the culture to emerge and dictate what role the state has to play, rather than doing what the state's doing, like top down, let's make all these rules now, but to actually, like, what are your thoughts about the possibility of a cultural emergence that includes the state as part of that emergence?
Are you sure you're going to remember all these questions?
No.
Okay. Well, my name's Dennis, and my question is more of a comment, I guess a question also, but my question goes to the root of, I think, something that's been overlooked in this debate over regulation of drugs, and that's kind of this issue of, to what extent does the state assert ownership over nature? And what I have not seen specifically articulated in the debate, and one possible solution to this drug war conundrum, what if the state or regulatory agencies as a first principle were to come forth and say, we'll make a distinction between plants and drugs, and we will say, plants we won't pay much attention to. We won't, to the degree that regulation is necessary.